Dean here at the University of Missouri Law School, and it's my happy task this afternoon to welcome you to our Missouri Law Review Symposium, Cyberbullying, Emerging Realities, and Legal Challenges. This promises to be a very full and very thoughtful and thought-provoking 2 days as our symposium unfolds. Cyberbullying, as we all know, is an aspect of our society and of our law that did not even exist until fairly recently. And last night I went on my computer at home and I Googled, another word that didn't exist until recently, cyberbullying. And in a mere 14/100th of a second, I was told that there were 10,600,000 hits on the word cyberbullying. And I'm confident that after the next 2 days, there'll be another 10 or 20,000 relevant to this particular symposium. When I was in law school back in the last century, my torch professor, Morton Horowitz, talked about the way in which one of the technological breakthroughs of the 19th century, railroads, pushed, changed, and challenged the American law at that time. And we're certainly seeing that in the 21st century with the impact of the internet on society and on our law. Today's symposium brings together a stellar cast of scholars and other experts from here in Missouri and around the country. I know you'll enjoy the symposium, and you'll also enjoy today's Earl F. Nelson lecture, which will be brought to us appropriately electronically, because Professor Palfrey has been ill, but comes to us via Skype later this afternoon. Now, our outstanding presenters will be introduced as they appear on their particular panels, but I'd like to thank all of them for coming from around the country. And so I wonder if you would just join me in thanking all of them. And we'd like to thank all of you for attending as well. We've got members of the, obviously, of our law school community, but others from well beyond as well. This symposium has been the dream for over a year of Professors Christina Wells and Doug Abrams, and it's been their vision and their hard work that has brought this wonderful symposium to us. So I wondered if you'd also join me in thanking Professor Wells. And there's one other group that we particularly need to thank, and we have seen them out in the hallways, we see them here. They too have worked for many months on this, and these are the members of the Missouri Law Review. I wonder if the members of the Missouri Law Review could stand so we can acknowledge and thank you for all of your hard work. Particularly acknowledge Editor-in-Chief Ian Larson. And I hope they do, some of the hard work of the members of the Missouri Law Review has yet to be done, but will be done to bring this wonderful symposium to the world beyond Holston Hall. We have with us several staff members who have helped. I see in the back Robin Nichols and Casey Baker. We want to thank them. In addition, Cindy Shear, Kathy Smith, and Risa Kern. These are always amazing efforts, and so let's thank them. All right, and now it's my great pleasure to very briefly introduce Professor Christina Wells. Professor Wells has been on the faculty here at the University of Missouri since 1993. She earned her BA with honors from the University of Kansas and her JD also with honors from the University of Chicago. She then worked as an associate at the firms of Skadden Arps in Chicago and Heller Ehrman in Los Angeles. She was a Fulbright Scholar in the Czech Republic in both 2001 and 2002, lecturing on constitutional rights and American constitutional decision-making. Her scholarly research is in the areas of free expression and access to governmental information. And in addition to her many scholarly articles, she is the co-author with one of today's speakers, Professor Lyrissa Lidsky, of a leading textbook on the First Amendment. Would you please join me in welcoming Professor Christina Wells, one of the creators of today's Law Review Symposium.
the really impossible to count people who were responsible. And I want to ask the indulgence, as I think people again, and in addition, because this doesn't happen because for those reasons, and I thought about this, it's really an effort that the whole law school gets behind. And I do want to reiterate my thanks to everyone who came and is interested in this topic, as well as all of the people who agreed to be part of it. And I want to thank Dean Dessem, especially, because ever since the idea of the symposium, the annual symposium with the Nelson Lecture was pitched to him about a decade ago, he's been incredibly supportive of it, and it's made a real difference, I think, at the law school and to what I do. And his support has been instrumental. So I ask that you thank him because he's part of the reason why the symposium is so important. In this room, because Professor Ben Trachtenberg agreed to give it up for his class, and Dean Raphael Helly convinced him to agree to give it up for his class, and Robin has provided organizational support to make those types of things happen. So that's a really important aspect of how we work together. Casey Baker provided an incredible promotional support, and I have to say that there are a lot of reporters that we've been talking to over the last week, and that's because Casey has really been out there getting the word out. And as you heard, our Nelson Lecture, unfortunately, we found out really early this morning that he is unfortunately quite ill, but is willing to do this anyway via Skype, and so we will talk to him. But he could not get on a plane, and if it weren't for the efforts of our IT department, and I mean really serious efforts of our IT departments, that wouldn't happen. So Daryl Yeager and Manny Velasco, Scott Weiser, Lisa Kearns, all deserve a huge round of applause for coming through today to make sure that we had a Nelson Lecture. How grateful we are to them. And of course, there's an enormous amount of IT support that went on anyway, but today they were helping us avoid panic, believe me. Ian Larson and Chirag Shah made this symposium happen. Professor Abrams and I had the idea, but Ian and Chirag planned it, contacted the participants, made sure that they had arrangements, they dealt with PR, they held our hands, they planned the menu. I mean, they did a lot, right? So both Ian and Chirag, I really want you to thank them again because they my daughter spelling bee last week, I know, but everybody really, really deserves that. So, okay, so now, why did we choose this symposium now? Right? And to talk about that, I want to do what seems like a little esoteric, but it does all make sense. We have the great fortune to have chosen this symposium topic at a time that temporally coincides with an important film that's coming out of the True False Film Festival. And if anyone who lives in Columbia knows that that documentary film festival is the pride of the city of Columbia. One of their featured films is a film called Bully. And if any of you have had the opportunity to see the trailer for that film, which is about the problem of bullying generally in the educational system, I assure you that 3 minutes of that film will break your heart. It is so compelling, and I can see why they chose it as one of their feature films. You don't have to be a parent. I have an 8-year-old daughter. You don't have to be a parent for that. You just have to be to understand that the issue of bullying is one that is really heartbreaking and emotionally very fraught. And so along with many high-profile suicides after bullying incidents, some of them cyberbullying incidents, it seems like the decision to have a symposium on that issue would be a no-brainer. And in many ways it was. But I want to step back from that movie, which I urge all of you to see, because it looks like it's going to be terrific, and talk about another movie. For any of you remember a movie with Jim Carrey and Kate Winslet called Eternal Sunshine of the Spotless Mind. Because I think it provides kind of an interesting juxtaposition. That movie involves a situation where two people meet and they are instantly attracted to each other in ways that is incredibly profound and they can't figure out why. But over the course of the movie, what they come to realize through different revelations from other people is that they have actually been lovers before. But because of the situation that they were in, they had a very difficult breakup. It was very ugly. They treat, at least one of them especially treats the other very badly. They have had their memories of each other erased through technology that doesn't actually exist. And so what you learn as the movie goes on is through the point of view of the Jim Carrey character, as you see him making the decision. The Kate Winslet character has her, she's the one who says, I want to have all trace of my memory of me erased, and she does that. And he makes the decision, I will do that too. And as he makes that decision to have his memory erased, you see him have that done, and as the memories are slowly disappearing, he comes to the realization that he's making a mistake, but it's too late. And he realizes he doesn't want to lose even those painful memories he had of that relationship. So two of the sort of themes of the movie are that he wishes he could retain those memories, painful as they are, because they're part of who he is. And they eventually meet up and figure out what's happened because of some sort of revelations that other people make to them. And they make the decision to have a relationship again, even though they are both convinced, potentially, that it will end exactly the same way. That they will break up and it will not be great. Right. So they decide to sort of relive their relationship. And so I think some of the movie, what it's trying to tell you is that to some extent their painful events are part of the fabric of our life. They are who we are. Maybe they're even integral to sort of becoming who we are as moral beings. At the very least, the notions of pain and suffering and happiness are integrally bound up together. And they're much more complex than simply saying pain is bad and happiness is good. It's a very complicated relationship. And I think cyberbullying is also equally complicated in terms of how to figure out how to deal with it. I mean, all of us can agree it is bad to be a victim of cyberbullying. I mean, it is painful and nobody wants to be a victim, and nobody wants anybody to know to be a victim of extreme bullying. It's a very bad thing. But the issue of how to deal with cyberbullying raises a host of very difficult questions. What is it? What is cyberbullying? What is it exactly that we want to regulate? How does it impact children? Is it different from bullying? Is it something that's similar? What kinds of emotional effects does it have? I don't think any of us doubt that it has significant emotional effects, but what are they? What's the best way to address it? Should we address it legally? Should we address it more preemptively? Should we address it through the schools? Should we address it some other way? And what difficulties arise when we do decide to address it legally? Are there constitutional implications to deciding to allow or force, in fact, schools to punish students or to address issues with cyberbullying? Are there administrative implementation concerns? How do school administrators feel about having to enact these kinds of rules and to deal with these kinds of issues? I mean, especially because much of cyberbullying is in off-campus situations. There's a lot going on here. It's a really complicated area. And it's difficult to untangle. And sometimes when you pull the thread, you don't untangle the knot. You actually create a new one. And that's why we wanted to bring together experts from all walks of life, not just legal experts. I mean, sometimes law isn't the answer, or sometimes it's only part of the answer. At the very least, you shouldn't make laws unless you're informed by other research. What are the social implications, psychological implications, the impact of administrators and educators. So we wanted to bring together people from all walks of life, and I think, we're very thrilled to have gathered a really great group of experts from all different areas to talk about what the impact of cyberbullying is, and how it impacts people in different ways, including some legal issues. Okay, so that's why Professor Abrams and I decided to have an interdisciplinary symposium that really tried to bring together lots of different ideas, and not just focus solely on the law, because the law itself is informed by many other things. So just gives you a little background. Now, having said that, what I'm going to do is throw 3 lawyers at you. And who are going to talk about the constitutional implications. All of them, though, are terrific, really great experts in the field. And the way that we would like to do this is I'm going to introduce all 3 of them, and then they're each going to talk for maybe 25 minutes or so, and then we'll throw it open to questions from all of you. We do want to give you an opportunity to interact with them. Okay, so here at the beginning of my great experts is Professor Ari Waldman, who is a visiting assistant professor at California Western School of Law. Professor Waldman is a widely published expert on internet law, cyberbullying, and the First Amendment, and also has blogged extensively on those topics on two very popular legal blogs, Prof's blog and Concurring Opinions. You can find his writings there, widely available. He also has worked with public officials and schools in terms of implementing anti-bullying policies, and he authors a weekly gay rights column on the nation's leading LGBT website. So that's Professor Ari Waldman. Professor Barry McDonald is a professor of law at Pepperdine University School of Law, where he specializes in constitutional law, the First Amendment, and intellectual property, as well as comparative constitutional law. Professor McDonald is the author of several scholarly articles on the First Amendment, and is also the author of a forthcoming casebook on constitutional law. He's a member of the Supreme Court Bar and clerk for Chief Justice William Rehnquist. So he was a clerk of the Supreme Court, has a great deal of experience when actually dealing with free speech disputes. And Professor Lyrissa Lidsky, over on the far end, is the Stephen C. O'Connell Chair in Law at the University of Florida, Levin College of Law. She's a free speech and free press expert who is the author of several casebooks with the dubious distinction of having been on one of them, on torts and media law, and as well as the First Amendment. And she's also in a number of related scholarly articles. And her area of expertise is especially with online defamation and anonymous speech. She also writes at the academic legal blog, Prof's blog. So we have a wide variety of expertise here. And I think what you'll find is we have a wide variety of viewpoints on this issue. And to the extent that we're going to be talking about legal regulation of cyberbullying and the problems it raises, I think you'll get a very nice debate going. So I will turn this over to Professor Waldman, and we can begin. Yeah.
Thank you very much, Professor Wells. Thank you for inviting me here today. Again, I'd like to add to the chorus of thank you to both to Professors Abrams and Wells, as well as to all the members of the University of Missouri Law Review, but particularly to Ian Larson for organizing this law. This is indeed an esteemed panel, and I am honored to be a part of it. This is also a very exciting time to be talking about these matters. But as exciting as legal thought in this area might be to those of us who really are professional law dorks, we have to remember that we're talking about cyberbullying and bullying in a tragic context. Between September 2010 and today, no fewer than 17 young gay children have killed themselves, and news reports tell us that it's almost entirely because of incessant bullying and cyberbullying. And those 17 reports are only the ones that are reported. And of those are the only ones where parents are not ashamed that their kids were gay. So we have to realize that while we're talking about this exciting area of law, we're talking about it in the context of tragedy. We can only hope that yesterday's positive Ninth Circuit decision in Perry v. Brown reminds some of these gay teens who are thinking about where they fit in the world that at least some people out there think that they deserve equal rights and that they belong. But today, I'd like to talk briefly, as the title suggests, about identity-based bullying and cyberbullying in schools, and argue that if we have an honest understanding of the Supreme Court's justifications for restricting student speech in Tinker, Frazier, Kohlmeyer, and Morse, we see that unique group harms associated with identity-based bullying satisfies any measure of those justifications for restriction. And for those in the room who aren't law students or law professors, hopefully I will be able to give enough of a basic background as to what these cases are all about. So, there are really three questions that we're going to talk about today. First of all, what is identity-based aggression? There's clearly a lot to talk about. We can spend hours talking about what we mean by aggression, what we mean by bullying, and what we mean by identity-based bullying. For now, let's consider identity-based aggression attacks on a victim based on who he or she is, or to use the lingo of the trade, aggression focused on intrinsic or unchanging characteristics that are essential to person. So these are just things about yourself that you cannot change. What are the special effects of identity-based aggression? Identity-based aggression affects individuals, but they also affect the individual victims, but they also affect the members of the group that identifies with that victim. And we're having a panel tomorrow of esteemed psychologists who are much smarter than I, and hopefully they can talk about that in detail. But for now, let's recognize, and we'll talk about it briefly, that there are effects on all members of a victim's identity group when you attack that essential characteristic, and of course, associated effects on the school. And then finally, what we're going to spend most of our time on, are these effects sufficient to justify school discipline of identity-based aggression? This question requires us to understand exactly what the Supreme Court is talking about and exactly what the court cares about when they decide to restrict student speech or not allow restricting student speech. For this talk, I will mostly be focusing on the final point, but we'll have to address each. The constitutionality of a school's discipline of its student speakers usually hinges on a broadly defined effects test. And that is true under Tinker, as well as under the trilogy of supposed exceptions to Tinker's substantial disruption standard. Tinker is our classic student speech case, which involved a group of students wearing black armbands to protest the Vietnam War. Even if the supposed exceptions to that standard, Frazier, which involved a student who at a school assembly gave a rather lewd but hilarious speech in advocating for the election of a fellow student to student office. Hazelwood v. Kohlmeyer, which involved school censorship of a student article in a journalism newspaper, in a journalism class newspaper. And Morse v. Fredric, which involved a drug-related speech, a student holding up a banner at the Olympic torch relay which said "Bomb hits for Jesus," which is a hilariously baffling statement in and of itself. Even if Frazier, Kohlmeyer, and Morse depart from Tinker, technically carving out an exception to the indicia of substantiality and disruption necessary to restrict lewd speech, a speech that would bear the imprimatur of the school, and drug speech, they do not depart from the underlying rationale that the reason we can restrict some student speech and not others is because of the underlying effects that that speech can have on the school environment, the educational possibilities, and the school itself. These types of effects can vary greatly on the teacher, the student, or other individuals, on the teachers or the school's ability to teach, on the administrator's ability to focus on the tasks of the day, on the school's academic performance, on the school's reputation, on the culture of safety of the school, and of course, on school discipline. So even just listing 1, 2, 3, 4, 5, 6, 7 possibilities from 7 different cases where federal appellate courts found sufficient indicia of sufficient reason to restrict school speech, we see that the courts are concerned, even under Frazier, Kohlmeyer, and Morse, they're concerned with what the effect this speech might have on the school. Now, some courts, like the Ninth Circuit, recently in Harper v. Poway, chose to ignore the underlying effects rationale for the ease of the second prong of the Tinker analysis. Tinker said in the 60s that the reason why you can restrict certain speech if it creates substantial disruption, if there's foreseeable disruption, or, and sometimes many lawyers forget about this, or if the speech at issue affects the rights of others. In Harper v. Poway, the court used that rights of others language. We'll talk about this case briefly. But as I'm arguing today, that deviation isn't necessary, though I appreciate the Ninth Circuit ingenuity in trying to deal with this problem. So if we consider honestly what we mean by effects, and take lessons from the Supreme Court student speech cases in their entirety, we need not deny or ignore the fact that a school that tolerates identity-based aggression is a sick school. where teachers cannot teach, where students cannot learn, where free speech means nothing, and where both liberal and classical values associated with education are tarnished. So, attacks and harassment based on who you are do not just affect you. They do not just affect the victim. They affect everyone that identifies with you. It silences you. If every time a young boy raises his hand in class and someone punishes him for an effeminate voice, or if every time one of the not cool kids says something, someone calls him gay or a faggot, or worse, those who identify as gay, or those who are questioning their sexual orientation, are therefore unwilling to raise their hands as well. It teaches also that, oh, here, sorry. Let's try that. There we go. It teaches also that the victimized group is not worthy of equal treatment. If a school tacitly accepts that attacking someone because they are gay, or because they are a woman, or because they are black or Asian, it teaches students that gays, women, and other racial minorities are simply undeserving of equal treatment. And therefore, it skews all of society's assessment of those minority groups. Not just that they're unequal, but also that they are victims, that they are weak, they are unable to contribute to society, and unable to handle the supposed realities of life. And this isn't just my word. You don't have to just take my word for it. I'm standing here on the shoulders of great legal and sociological scholars, including legal scholars at the University of Maryland, the University of Colorado, Daniel Citron and Helen Norton, who have identified many of these group harms associated with harassment based on intrinsic characteristics, like being a woman or being gay. Cyber aggression makes this worse. The pseudonymity of the internet tears down social barriers to evil. It reduces the social cost of harassment. Nasty comments or doctored photos are also permanently part of the endless internet that's accessible through any search engine. And perhaps most importantly, for identity-based aggression, it takes what used to be a safe haven and turns it into a sword. Gay youth throughout this country turn to the internet in greater numbers and in greater percentages than any other group because their physical community surrounding them may be hostile. And they find protection, and they find a safe haven online. But when that environment is turned from a safe haven to another place where they can be harassed, that magnifies the effect of harassment. Imagine if you had no place to go for what I call Ari time, or what you call your own time. Imagine if you had no place that you considered a safe space. That's what many of our gay teens today in places like New York, California, as well as Missouri feel every day. And this has clear and evident effects on the school. If bullied for their identities, and these victims and those that identify with them do not participate in class or integrate themselves into the school community, they don't learn. Their test scores suffer. The unity of the school community suffers. And the schools in general scores and success of their students suffer. And a school that tolerates this kind of behavior teaches inequality, teaches harassment, and discrimination by example. The educators in the room will know that you don't simply learn in school when you're in a classroom listening to a teacher. I know many of my students don't learn anything from me. They learn from their fellow students in the hall. They learn from interacting with one another. They learn from the examples that are set by those that they put in, those that they see in authority. And when a school tacitly accepts, or in some cases, like in the Anoka-Hennepin district in Minnesota, verbally accepts the harassment of gay teens, what else are they to think? And the school suffers as a result. These kinds of effects on the school, and these kind of effects on large groups or large identity groups in a school, are precisely the kinds of effects that federal courts have recognized are sufficient to warrant regulation under any student speech analysis, whether it's Tinker's substantial disruption standard or any of the three exceptions. We don't even need a modern or broader conception of substantial disruption that accepts the best sociological evidence that we have today. We also can look to the lessons of Fraser, Kohlmeyer, and Morse. And we read these cases and then have to ask ourselves, why else would we be concerned about lewd speech in a school, speech about controversial topics that may be inappropriate for young readers in a newspaper, or speech that apparently encourages drug use, if not for the effect that that speech could have on the school environment, the ability of those teachers to teach, and the school as a whole. So first, let's consider Tinker's substantial disruptions. No one thinks that Tinker is confined to its facts, namely protest, nor are we simply to believe that the disruption that Tinker spoke about only refers to the disorder associated with a protest or a riot in school. And we know this from a long line of federal cases that's too innumerable to list today. And while there's no precise test for what defines a substantial disruption, various courts consider, for example, the reaction of students and teachers to this speech, whether any student or teachers had to take off time from school because of the effect, whether teachers were incapable of controlling their classes, whether classes were canceled, and how quickly and to what extent administrators had to respond to the speech. Consider now Judge Posner's decision at the Seventh Circuit in Nuxall. Nuxall involved a student who wore a t-shirt that said, "Be happy, not gay," on the front. He said it was in an exercise of his religious beliefs, which said that homosexuality was not to be tolerated. He and a number of his friends organizes this day, the day where he wore his t-shirt, in reaction to GLSEN's Day of Silence. GLSEN is the Gay, Lesbian, Straight Education Network. And GLSEN's Day of Silence, which happened the day before this incident, was a silent protest. Gay students and those and straight allies would not speak the entire day in order to draw attention to the extent of anti-gay harassment, both in their school and in all schools. Judge Posner wondered, well, what would constitute a substantial disruption? And he found that a particular type of student speech that will lead to a decline in student test scores, an upsurge in truancy, and other symptoms of a sick school, symptoms therefore of a substantial disruption the school can forbid. So as he learned, and this was after a relatively long opinion, where he took lessons from Fraser, Morse, Kohlmeyer, as well as a slew of opinions from the Seventh Circuit and his sister circuits, talking about substantial disruption and in general, why we want to restrict certain speech. Based on the consistent rationale underlying Fraser, Kohlmeyer, and Morse, we know too that these kind of effects on the school are precisely what the Supreme Court is concerned with in its exception cases. It would be wrong to say that the court, by permitting restrictions on lewd speech in Fraser, on speech that could bear the imprimatur of the school in Kohlmeyer, and drug-related speech in Morse, that the court completely ignored the effects or the disruptive possibility of that speech on the school or on students. These cases may have accepted a lower effects test for determining when it's okay, or determining that it was okay to restrict certain speech. But that's even hard to say for some scholars because the substantial disruption standard is itself so amorphous. So why do we care about a school tolerating lewd speech at a school assembly? Well, because of the effects it would have on students who heard it and the school that tolerated it. As the court said in Fraser, the pervasive sexual... Let's try this. Sorry, this is a new one. There. The pervasive sexual innuendo in Fraser's speech, and you can imagine the kind of sexual innuendo that a 14-year-old boy would find hilarious. The pervasive sexual innuendo, and of course some of us in this room too, was plainly offensive to both teachers and students, indeed to any mature person. By glorifying male sexuality and its verbal content, the speech was acutely insulting to teenage girls. The speech could well be seriously damaging to its less mature audience, many of whom were only 14 and on the threshold of awareness of human sexuality. Some students were even reported, you can tell it's the Westlaw version, were reported bewildered by the speech and the reaction of mimicry and provoked. Now, this may not have arisen, the reaction of mimicry may not arise to the level of a substantial disruption. But why talk about this if we're not concerned with effects? Clearly, the court was interested in the fact that this lewd speech could have an effect on the school and disrupt a teacher's and administrator's access to the open minds of its students. Why do we care about a Why do we care about why do we care about a school tolerating controversial or hot topics in a student's in an official journalism class newspaper? Well, once again, because of the effects that it would have on the students in the school. In Kohlmeyer, the principal was concerned about what would happen if certain identities of those those who were listed in an article in a student newspaper about teen pregnancy and divorce. The principal was concerned with what would happen to these students if their names got out, and what would happen to the school if it got out, if this community heard that they were supposedly endorsing teen pregnancy. Educators are entitled. Sorry. Ms. Frazier. Here we go. Educators are entitled to exercise greater control over the second form, speech that bears the imprimatur of the school, to assure the participants learn whatever lessons the activity is designed to teach. If a school can't determine what it's going to be in its own journalism curriculum, they lose control of the journalism class. That readers or listeners are not exposed to material that may be inappropriate, and that the views of individual speaker are not erroneously attributed to the school. Why are we concerned about that, if not for the effects that that school could, that speech could have on the school? Otherwise, the school would be unduly constrained from fulfilling their role as a principal instrument in awakening a child to cultural values and preparing him for later professional training and helping him to adjust normally to his environment. Whatever you think about using that type of value judgment as the basis for the purpose of a school, we can set that aside at the moment. But for our purposes today, let's just admit that the court is concerned about the effects that that kind of speech would have on those values. But it's bigger. And why do we care about tolerating drug-related speech in Morse? Well, because of the effect that drugs could have and drug-related speech could have on the school and the students. Here we see in Morse v. Fredric, the court spent pages going through the extent to which this nation has gone to fight the war on drugs and talk about the effects that drugs have on kids, young people specifically. School years are a time of maturation. Maturing nervous systems are more critically impaired by intoxicants, etc., etc. Pages and pages of this. The special characteristics of the school, the court said, and the government interest in stopping student drug abuse reflected the policies of Congress, and a myriad of school boards allow schools to restrict student expression. It wasn't merely because there was drug mention. It doesn't really because there was a mention of the word bomb in a poster, and someone didn't like the word bomb. It was because of the effect that that drugs could have on schools and on students. The same can be said of the devastating group harm associated by caused by identity-based bullying and cyberbullying in schools. No one wants a school where its minority students never raise their hands, or where they feel so unsafe to walk the halls and therefore stay home, or where they feel so victimized that their educational growth and social maturation are irreversibly stunted by anxiety, depression, and suicidal ideation. These are sick school symptoms if there ever were any, under any measure, and it impairs a teacher's ability to teach and a student's ability to learn. Finally, let's talk a little bit about some implications of this theory. The recognition of group harm, that group harm exists, and that it is associated with identity-based bullying and cyberbullying, reflects both the classical and the liberal values that are mixed together in public education. It recognizes that schools both should be in the business of making good citizens, obviously citizens that discriminate and harass simply because you're different are not the kind of citizens that we want to create. And it also recognizes that if minorities do not feel safe enough to participate in school, the entire school cannot benefit from the free marketplace of ideas. Also, group harm metastasizes when members of a harassment victim's identity group see their community at large and see it as unsupportive and complicit. Professor Wells started this symposium by saying that we all agree that it's terrible to be cyberbullied. It's terrible to be harassed. But unfortunately, I have to disagree. There are many people out there that think it is A-okay to harass and attack someone for being gay. And in fact, Focus on the Family, for example, makes a career out of it. And Tennessee recently passed legislation that exempted any student or anyone from anti-bullying laws if they can justify it by recourse to their religious beliefs, giving them an excuse to harass for your identity. So unfortunately, we don't live in a world where everyone thinks cyberbullying and bullying are bad, especially when you're talking about gay students. Hateful comments, discriminatory legislation, and the kinds of comments that come out of some of our presidential contenders, or former presidential contenders, remind gay teens that, especially, that their leaders are hostile to them, which gives tacit approval to their harassers. After all, if the world thinks that gay people are undeserving of equal treatment, why should bullies ever stop harassing them? And this analysis holds regardless of where the speech originates, whether on campus, face-to-face bullying, or off-campus cyberbullying. As I've argued elsewhere in an article coming out in the University of Maryland Law Review, there's little basis for a strict geographic distinction, limiting limiting the reach of the school's discipline to on-campus harassment, to on-campus bullying, rather than and excluding anything that happens outside the schoolhouse gate, for various reasons. Pervasiveness of the internet, the lack of geographic requirement in any of our cases, and the permanence of harm associated with digital aggression. We therefore need not be afraid of using an effects test or a substantial disruption test for restricting identity-based bullying in schools. And we also need not be afraid of the classical values associated with allowing schools to teach good citizens. Both of these work together in determining and help us to say that identity-based aggression, which under any standard and under any standard of what the purpose of the school is simply not to be tolerated. Thank you.
Well, I'd also like to thank Professor Abrams and Professor Wells and Ian and Shrog and the rest of the Missouri Law Review for putting on such an interesting and timely and important symposium. My talk is going to have a little bit of different focus than Professor Waldman's talk, whereas he was addressing the problem of group or status bullying. I'm going to address kind of the more traditional way we think about cyberbullying, student-on-student cyberbullying, and to what extent schools can regulate and discipline that sort of bullying without violating the First Amendment. I'm going to spend very little time on the problem of student cyberbullying because, as Professor Wells mentioned, that problem is being identified and talked a lot about by various different sources, and so we know that online bullying of students by other students is becoming a major social problem. Indeed, in March of last year, President Obama held a White House conference on the prevention of bullying. Studies show, they vary in their numbers, but they show that roughly 40% of kids report having been bullied online, usually in association with some sort of school relationships. And so this is becoming a real problem for the schools. Schools are being asked to address it by state legislatures. They're being mandated to address it, and they're being held legally liable if they don't sufficiently address it. And as Professor Waldman suggested, when we're talking about cyberbullying occurring in schools, we can think of it as like the traditional schoolyard bully on steroids. It can be done anonymously. It can be done by a distance, which brings more students into the fray that are more willing to commit bullying, who otherwise wouldn't be willing to do it if they had to face people in person. The effects of it are much more widespread. Group bullying groups can be brought in much easier in cyberspace to commit the sort of bullying, and the effects are long-lasting. And I'm sure many of our experts in here today will be talking more about the problem of group cyberbullying. So I'd like to move quickly then to the main question that I want to focus on, which is to what extent can schools police and discipline students consistent with the First Amendment when they are accused of engaging in cyberbullying. And this is a particular problem where the cyberbullying occurs off campus, because most of the Supreme Court's precedent that Professor Waldman discussed had to do with in-school speech, with one minor exception, but the court has never really fully addressed the question of to what extent schools can impose these sorts of sanctions outside school grounds. And so lower courts, as I'll talk about, are really struggling with this question. But first, before we get into that, we have to figure out, as Professor Wells talked about, what is it exactly we are talking about when we're talking about cyberbullying? Because First Amendment doctrine, according to the Supreme Court, as it has developed it, is all about categories of speech. So it's either a low-value category of speech, or it's a high-value category of speech, or it's the government acting in a special capacity category of speech. And the court tends to develop special rules depending on the particular type of speech you're talking about, because First Amendment issues are very contextual. Different sorts of speech present different sorts of free speech interests that run up against different sorts of societal interests. And so, I think it's really important to define with some degree of specificity what it is we're talking about when we're talking about cyberbullying. Now, I think intuitively, we think of it as, a girl receiving an email, "I can ruin your life, no one likes you, loser," and being experiencing emotional distress. But it can be more attenuated, such as when somebody is bullied and somebody else takes a video of that and they publish it to embarrass that person. So cyberbullying can exist in all forms, and that just complicates the free speech analysis involved in these sorts of cases. Further complicating it is the various definitions that both courts, states, and nonprofit organizations have developed to define cyberbullying. For example, the National Conference on State Legislatures, which kind of compiles state laws relating to certain subjects, defines cyberbullying as the willful and repeated use of electronic communication devices to harass and threaten others. And I've emphasized the word repeated because perhaps that's the definition that we most associate with kind of the concept of traditional bullying, where somebody is being repeatedly bullied by a particular individual. That's kind of what we've traditionally thought of as bullying. But yet, for example, the National Council on Prevention of Crime defines it much differently. The use of electronic devices to send or post text or images that are simply intended to hurt or embarrass another person. Now note that there is no element of repeated conduct in this definition of bullying. So one incident of somebody sending a hurtful, embarrassing text message or an email, for example, could constitute cyberbullying under this definition. And so I would call the first definition, the NCLS definition, more of a narrow version of cyberbullying, because you need this kind of repetitive harassing conduct to be called cyberbullying in that context. But here is a much broader concept where one hurtful or embarrassing email can conceivably amount to cyberbullying. And to add to the fray, we have the California Education Code that defines it even differently. Severe or pervasive communication, and this is based on kind of federal anti-discrimination laws, severe or pervasive communication that a reasonable person should know would cause a harmful effect on another person. And again, I would say that this could be more of a very broad protective definition of cyberbullying victims, because again, there's no element of a requirement that this be repetitive sort of conduct, harassing conduct towards a person. So we have all these different narrow and broad versions of what cyberbullying is, and as I'll talk about later, it does complicate the free speech analysis, because to the extent that you have very protective definitions of what cyberbullying is. Obviously, you know, the free speech interest in allowing students and youth to say things of a hurtful or offensive nature. I mean, there are some free speech interests there because, as Professor Waldman talked about and the court has recognized, youths are growing up, they're maturing, they're developing, they're making mistakes, they're learning from them. And so, to the extent that you have these very broad, protective versions of what cyberbullying is, it does raise a lot of First Amendment concerns in terms of schools being able to officially punish those forms of expression. And I'll talk about that again a little bit later. But at the core, as it says here, these definitions tend to focus, you know, if we were to distill kind of the essence of what they're focusing on, and here we're talking about student-on-student cyberbullying versus the group or status bullying that Professor Waldman was talking about. I think we could distill it to students sending or posting electronic communications that cause psychological distress or harm to another student. Okay, those are the deep competing definitions of cyberbullying that complicate free speech analysis. But what also complicates free speech analysis are the different forms of cyber speech that schools have to deal with. If you take a look at the National School Board Association website, in August 2011, they did a comprehensive compilation of all the, as it says, off-campus online student speech cases that have been decided roughly over the last decade. And it's illuminating what the nature of these cases say about the variety of student cyber expression that's out there. 13 of these 21 decisions don't involve what I would call cyberbullying, but involve what I would call cyber dissing, where students are posting content online that mocks or ridicules school personnel, school principals, school teachers. Yet, courts are kind of treating cyber dissing in the same way that they're treating cyberbullying. They're kind of conflating the two types of situations. I think that's a mistake, because I think cyber dissing presents much different First Amendment concerns than cyberbullying. You know, when we're talking about cyber dissing, we're mainly talking about the criticism of authority, the criticism of government officials, which goes to the heart of the First Amendment protection. And also we're talking about, when you're talking about cyber dissing school officials, we're talking about mature adults that, you know, should be much better able to handle that sort of thing than a vulnerable youth, you know, from 9 to 14 years old, where most of the studies say most cyberbullying occurs. And so to just kind of conflate cyberbullying and cyber dissing cases from a First Amendment perspective, I just think it's a big mistake. And so I'm going to talk about how, I'm not going to focus on cyber dissing, but at some points I'll talk about you know, why it matters to distinguish cyberbullying from cyber dissing. The other 5 forms of cases is what I'd call, or 5 of the 21 cases, is what I'd call victimless cyberbullying. What I call either cyber blustering or cyber jesting. And this is where you kind of have a group of students, usually buddies, that throw up a website and they just do what kids do. They bluster. And so they have lists of which kids are cool, which kids are losers, which kids should die. But you know, there's just no evidence in these cases that any of these communications were ever targeted at the listed students. In other words, they were just posted somewhere in cyberspace. Someone took note of them, usually not the victim, because there were no complaining victims in these particular cases. And the schools took action against the students. Now I think, again, that cyber blustering, cyber jesting presents different First Amendment concerns or free speech interests than kind of true cyberbullying, where you have one student directing communications to another student that are hurtful or abusive. And so again, I think it's important to distinguish this type of cyberbullying from what I'd call kind of traditional cyberbullying. Another of these 21 cases didn't involve cyberbullying at all. The school punished students for engaging in cyber exhibitionism by posting some images with graphic content. And then finally, only 2 involved what I call true cyberbullying, where a student was posting content and getting other students involved in, both cases involved casting sexual slurs against a co-student in the school. Why, out of the last decade, we only have 2 true cyberbullying cases, but 13 cyber dissing cases? I mean, one can only speculate. It may be that, schools are punishing cyber dissing more harshly than they are true cyberbullying. It may be that, parents are more willing to engage lawyers to fight school boards because of, kind of our traditional First Amendment notions that we should be able to criticize government action. So it may be that parents are much willing to fight school boards when the students are being punished for cyber dissing versus cyberbullying. Okay, so having set that stage, now I want to talk about the unique free speech interests and countervailing societal interests involved in schools disciplining students for true cyberbullying, which is kind of at the heart of this particular conference. So to set the stage from a First Amendment perspective, broadly speaking, the Supreme Court, in its first free speech rules that it has established, it makes the punishment of cyberbullying difficult for government authorities, unless you can say that that type of bullying falls into kind of an exception to First Amendment protection that the Supreme Court has recognized, like it constitutes a true threat that's, you're going to hurt somebody, or you've defamed somebody and it doesn't involve any matters of public concern, or you publish somebody's private facts, again, where it doesn't involve any sort of public issues, or you've engaged in a pattern of harassment towards a particular student, which, when you're talking about the narrow definition of cyberbullying as containing that kind of repetitive element, I think it's much easier for schools to police that sort of conduct, because many courts have said harassment, being a combination of speech and conduct, are able to police that consistently with the First Amendment. But when you're talking about the broad versions of cyberbullying that would, can conceivably punish one hurtful or offensive email or text message, that's where you don't have a First Amendment exception that schools can resort to say that we are able to punish this sort of speech. In fact, general free speech law says that if you are talking about merely intimidating, insulting, or embarrassing communications, those are generally protected under First Amendment law, under this, what the court calls a content neutrality principle, that the government basically shouldn't be telling people what they can or cannot say based on the content of their message. Okay, but, and here's a big but. So generally, if you were outside the school, governments would have a very difficult time regulating kind of what we think of as traditional cyberbullying. Yet the court has allowed greater regulation of speech in schools on the theory that when the people have delegated certain functions or tasks to certain organs of government that they want them to perform, like when they delegate the task of public education to schools, then those institutions should have a greater power to regulate speech that might interfere with the accomplishment of the particular government organ's assigned mission or function. So I would call this a functional rationale. The court gives certain government institutions greater power to restrict and regulate speech if that speech is going to interfere with the effective accomplishment of the delegated task that the government has given a particular government organ. So, for example, as Professor Waldman was talking about, we see the court having basically carved, and I won't go through these again, certain exceptions where the government can punish speech in school that it would not be able to punish outside of school under kind of ordinary First Amendment principles. The main one being Tinker, where the court says you actually can punish student speech on the basis of its content, on the basis of what the student is saying, if it would create substantial disruption to school operations, or it would constitute an undue invasion of the rights of other students. And this kind of special functional rationale, or these special functional rules, aren't limited to public education. When government, for example, owns buildings and people want to give speeches on their property, special rules apply. When government acts as an employer, special rules apply to what their employees can say, and et cetera, et cetera. So this kind of functional theory gives the government, in certain settings, the special powers to regulate speech that it wouldn't otherwise be able to regulate. Okay, so the key question in these cases is to what extent this special functional power extends beyond the physical boundaries of a particular government institution. Now, there was a very brief discussion of this particular issue in the Bong Hits for Jesus case that Professor Waldman discussed, where there was an argument, because the banner was being held across from the school, not on school grounds, they said, well, student speech rules don't apply. We should be able to say what we want under the First Amendment. The court rejected that on the theory that it was a school-sponsored activity where the banner was being held. So the court has suggested at least one exception to these special powers only applying on campus, and that is where you have a school-sponsored activity occurring off campus. But that doesn't really help us in these cyberbullying cases, because a lot of these aren't school-sponsored activities. But there is at least one other decision in these kind of government employment cases where the government is punishing the speech of its employees that does suggest that these special functional powers can extend as far as it's required in order to protect the institution's legitimate interests. And that's the case called City of San Diego versus Roe. And you might wonder why I have such a bizarre graphic posted. Well, it was because this case involved a San Diego police officer who on his off time was making and selling private sex videos of himself in a police uniform engaging in these sex acts and then selling on eBay. Now, the City of San Diego tried to fire him for that, saying it was conduct unbecoming an officer, it was immoral, it was damaging to the functions of the San Diego Police Department. The Ninth Circuit Court of Appeals ruled that it was unconstitutional, it was a violation of his free speech rights to fire him. On the theory that, well, this was just all private stuff, and so they can, the government can only exercise kind of their special functional rules when, he's acting as a police officer, or he's otherwise in the course of his employment. The Supreme Court summarily reversed the Ninth Circuit and said, okay, I think you need to study our cases a little bit harder. We didn't just say that the institution's interests kind of stop at its physical borders. What he was doing in the privacy of his own home was damaging the interests of the San Diego Police Department. And so the court allowed him to be fired consistently with the First Amendment, suggesting that special functional speech powers can extend as far as necessary in order to protect an institution's legitimate interest. And then, of course, in cyberbullying, what does that mean? So what is the reach of these schools to be able to, address these cyberbullying cases that occur off campus? Lower courts are struggling with this question, which is to what extent do the special powers extend off campus, or to mixed location speech, i.e. where the cyberbullying originates off campus and then is delivered on campus by students accessing that sort of content with their cell phones or computers on campus, etc. The second big question that they're dealing with is, well, once we decide that we have what I call jurisdiction, so once you decide that you can exercise your special speech powers over cyberbullying, you can exercise jurisdiction, to what extent then, what should the rules be on the merits of these disputes to help schools resolve them? Now I see that I'm already over my time, so I'm only going to address this first question, and then I'll let you read my article that comes out in the Missouri Law Review if you're interested in how I would suggest. What's that? Okay, well, okay, I'll try to go really fast. Okay, reach a school of power. Since most cases involve this cyber dissing phenomenon with school officials, courts are understandably employing this kind of substantial disruption of operations rationale to address this particular problem. This is kind of an esoteric point. Let me let that one go right now. But the big point I want to make is that in these cyberbullying cases, the courts are basically unthinkingly following suit and basically saying, well, when a student gets bullied, have the operational processes of the school been sufficiently disrupted to be able to punish the cyberbullier? I'm saying, contrary to what Professor Waldman was arguing for group bullying, I'm saying that for student-on-student bullying, substantial disruption is not the significant interest of the school in these cases. That interest is to protect the capacity of students to be able to effectively learn, where the impairment of that learning capacity arises out of school-related events. So under kind of the San Diego versus Dole reasoning, the school's reach should be able to extend as far as reasonably necessary to protect that interest of the school in shielding a student's learning capacity where it's been harmed because of school-related events. And what I'm saying here is that a school's legitimate interests aren't just limited to school grounds. I mean, as a parent of a 9-year-old, 6-year-old, and a 2-year-old, and working with my kids every night with their homework, I mean, a school's educational interests just don't stop at the schoolhouse gate. They do extend into private homes, and a student's ability to be able to do homework, that's a critical part of the learning process, could be impaired by cyberbullying just as much as when the student is sitting in class listen to their teacher. So where does that lead me? So for a proposed jurisdictional standard then, by which I mean when can schools kind of exercise this special power to regulate speech outside of school walls, I'm going to suggest taking this kind of form, content, and context standard that the court applies in these government employee cases like the San Diego versus Roe case that I just have out there. Basically, in those employment cases, they ask about the form in which the speech occurs, the content of the speech, to be able to answer the question of whether the government can discipline the particular employee. If you use this test and you determine that the employee was kind of speaking as a citizen on a matter of public concern, you can't, then the employee gets First Amendment protection sometimes. I mean, then there's a balancing analysis the kids can. But if using this test, the court determines that really what we have is a employee that is just involved in a private employment dispute, then there is no First Amendment protection, and the government employer can sanction the employee for the speech. I think if you apply this to the student speech context, essentially what you would be able to do is use this sort of standard to assess when the student bully is speaking primarily in their capacity as a student versus a general citizen, and you're asking the question, did the speech arise out of interactions or events that occurred under the school's supervision and control? If so, then I think this form, context, and context standard spits out the following result in terms of when schools can basically extend their special reach power to reach private cyberbullying. So if you ask about, so it's a form, context, and content standard. So if you ask about, well, what was the content of the bullying speech? Did it arise out of school interactions, or was it related to school activities? To things that happened under the supervision or control of the school officials. No matter where the school occurred, where the speech occurred, and that's basically what I mean by the form of the speech. I think in those instances it's legitimate then for the government to exercise its regulatory powers. And really here we're just talking about schools being able to discipline students for that sort of speech. Where it gets really sticky, in my estimation, is when the content of the bullying is unrelated to school interactions or activities. In other words, let's say the kids just grew up in a neighborhood together, they don't like each other, but they happen to be students in the same school, cyberbullying occurs, should schools be able to reach that with their special regulatory powers, even though one of the students' learning capacity is definitely being impaired? That's where I'd say, that's where I think the location of the speech becomes important. If it's all occurring exclusively on campus, then even though the subject matter doesn't arise out of school-related events, I think it's still fair enough to say that the school can exercise jurisdiction. But let's say that if the cyberbullying originates off campus, but the cyberbullier directs it on campus, either actually by accessing it, say, on a cell phone on campus, or constructively by including a lot of that school's classmates in the bullying that goes on, knowing then that there's a high likelihood that bullying speech will reach school grounds. Again, in that sort of case, I think it's fair enough for the school to exercise jurisdiction. Where I don't think that the school has legitimate enough interests at stake is where the subject matter has nothing to do with school-related events, and we're talking about either exclusively off-campus cyberbullying or speech that originates off campus and just incidentally makes it onto campus, i.e. where the speaker couldn't be said to have had a high degree of knowledge that speech would be likely to reach the campus environment. So, I'm going to stop. That's my proposed solution to at least the jurisdictional dilemma. And in terms of the standards for addressing the merits of these disputes, again, I'm sure the Missouri Law Review edition will be out soon, and you can read all about it there. Thank you.
He doesn't get off that easy. There's a question to be answered. But before that, Professor Lyrissa. First, thank you very much for having me here today. It's really exciting to be here in Columbia. This is my second time to be in Columbia. I'm very glad to be back. And I just wanted to thank everyone who has done all the work to make this symposium happen. I know how much work it takes, and I really appreciate all the efforts on my behalf. And I thank you in advance, Law Review students, for the work you will do in getting our articles ready for publication. Now, to make sure, before I get started, just to make sure I leave you with a kernel of wisdom today, I want to tell you something I learned today. If you, like me, go to an airport and you dress in a navy blue suit and a white shirt, and you also decide you're going to do the scarf thing too, you can get discounts on your coffee. Twice. So don't say I didn't leave you anything about it. All right. The title of my talk today is Coming to Terms with Cyberbullying. And in part of it, I will be channeling Professor McDonald, although I assure you it was not coordinated in advance. There is no doubt that cyberbullying harms. In fact, we have documented cases in which cyberbullying kills. The names of Phoebe Prince of Massachusetts, Seth Walsh of California, Jamie Rodemeyer, of New York. All of these children, Tyler Clementi, all of these children who have taken their own lives as a result of the bullying and or cyberbullying they experienced have made national news, and they should. There's a growing consensus that this is a serious harm. And even the survivors of cyberbullying sometimes carry the harms it causes into adulthood. There's not just a growing consensus that this is a serious harm. There's a growing consensus that it's reaching epidemic proportions, although reliable statistics on that point are a little harder to come by. Legislatures across the country have responded, as you would expect. A majority of legislatures, state legislatures, currently have some sort of legislation affecting cyberbullying. Of those, 14 jurisdictions explicitly use the term cyberbullying in their legislation, and there are 6 state proposals on the table that represent cyberbullying legislation. There's also a federal proposal. I believe that one's called the Megan Meyer. She's from, yeah. So
So there's federal law on the table. And as I say, all of these statutes are responsive to the perceived social problem of cyberbullying. What could be wrong with that? We could have quibbles with that. Well, one of the problems is that a lot of this legislation is conflating its legal definition of cyberbullying as a problem with the social definition of cyberbullying as a problem. Even that narrow definition that Professor McDonald pointed out from the National Conference of State Legislatures is potentially overbroad if unthinkingly adapted into a statute. Remember it said the willful and repeated, how many times? Willful and repeated use of electronic means to harass another. What does harass mean? That would have to be filled in, have any hope of constitutionality. Now, a lot of this new legislation is simply taking the social definition of cyberbullying, putting it into statutory form, and what could be wrong with that, right? They want to get at the problem broadly. It's a big problem. Let's go at it big time. Let's go at it in a big way. Well, what's wrong with that is it results in a lot of legislation that's probably unconstitutional. It's probably overbroad. And that results in a misdirection of prosecutorial resources. I'm talking mainly about criminal law here. So they were talking mainly about the school context. I'm talking about criminal legislation for cyberbullying. So it misdirects prosecutorial resources. It misallocates taxpayer money that is used to pass the legislation first and then defend it against the inevitable constitutional challenges that come. And finally, it blocks the passage of meaningful legislation that can get at the problem of cyberbullying. Now, I'm picking on New York because New York has the latest cyberbullying proposal to come down the pike. But I could pick on other places, say a jurisdiction that sought to criminalize knowingly causing emotional distress to another person by anonymously making an electronic communication. Okay, so that's a little overbroad. I'm going to pick on New York though.
I'm sorry.
Sorry,
Just a little. Sorry.
Yeah, I know that Missouri should have consulted its resident expert, but clearly they erred. Okay, clearly. Okay, so here's the New York proposal. First off, the New York proposal is typical of other legislation of this type in several ways. It's typical because it was directly triggered by a tragedy. It was triggered by the tragedy of two teens in New York who killed themselves. One was Jamie Rodemeyer, who was a teen who did one of those videos, It Gets Better. But eventually, according to his parents, he succumbed to the pervasive bullying he suffered based on his sexual orientation and killed himself. The other was a girl named Amanda Cummings, who became so desperate because of girls. It sounded like it was a series of girls talking about her, demeaning her. And she threw herself in front of a bus and was killed. And so a Democratic senator, state senator from New York, set up a website to take in stories of cyberbullying. And then he proposed a new New York statute. And there's a congressman, too, who has a companion bill. And let me give you a little bit about the new New York statute. First off, it modernizes pre-existing legislation to make clear that some of the offenses like stalking or harassment can be committed by electronic means. And this is a common pattern in all the legislation of this type. Okay, so that's absolutely typical. The other, though, is the law increases criminal penalties. Now, I'm only talking about criminal laws. Criminal penalties for cyberbullying of children under the age of 21. Right, and you have to think that this law was probably influenced by the Tyler Clementi case, which occurred at Rutgers University. So it was an older than usual instance of teen cyberbullying. But so it's cyberbullying of children under the age of 21. And it broadly defines the activity that qualifies for criminalization. Okay? So it links cyberbullying with stalking. And it states as follows. And I'm sorry, I should have a slide for this. If you ever had a statute, you should have a slide. But I had slides. but I had a technology paranoia, knowing I was coming in 30 minutes before I was supposed to talk. I didn't want to add the technology complication too. So here's the statute. Okay. It says a person is guilty of stalking in the third degree. Stalking in the third degree, when he or she intentionally and for no legitimate purpose engages in a course of conduct directing electronic communication at a child under the age of 21, and knows or reasonably should know that such conduct causes material harm to the physical health, emotional health, safety, or property of such child. Now, even though the statute says it's committed by a course of conduct, it clarifies that even a single communication to multiple recipients about, and not even necessarily to the child at issue, but about the child, can constitute a course of conduct under the statute. So what's the problem with that? Well, it's certainly well-intentioned, but it's also certainly sloppy drafting. Okay? One of the problems with it is the mens rea element. You reasonably should know. You can be liable if you, for a crime, if you reasonably should know that there will be material harm, whatever that means, because material harm is not defined. You reasonably should know that your communication will cause material harm to the emotional health of a child, defined as anybody under 21. So, for example, under that standard, let's say you have some teen girls texting one another about the attire of a friend or a former friend, more likely, is wearing at school. A repeated pattern of texting about her attire or her appearance, which actually is one of the most common forms of cyberbullying. Okay, the appearance related, that's one of the most common forms. The sexual identity is one of the most common as well. But anyway, they're texting about the appearance. And then one forwards it to the target. That can be encompassed within the statute. Here's another thing that could potentially be encompassed within the statute. Let's say you have a student who's in college, he's 20 years old. He and his girlfriend break up, and he posts on, Facebook some aspersions against her. She's crazy, I'm glad he broke up. He reasonably should know that it will cause a material harm to her emotional health. Can he be prosecuted under the statute? This statute is clearly overbroad in a way that infringes on constitutionally protected speech, and it's not accidental at all that it's overbroad. In the justification statement for the legislation, the legislator said, I want to go after adolescent cruelty, okay? Which is, as a social end, is perfectly acceptable. As a legal end, it is certainly overbroad and entrenches on First Amendment interest. And so, what I'm arguing for, now, one of the things he said in his justification statement is that new tools may be needed to deal with cyberbullying, new legal tools. And I certainly am in agreement with him that new legal tools are needed to deal with cyberbullying. But I would have a plea about the way we address coming up with new legal tools for cyberbullying. Okay? One is, not all tools to deal with cyberbullying have to be legal. Right? We have socialization, we have stigmatization. The other is, when we have legal tools, we can have them in education codes that direct certain forms of education to try to eliminate the problem. We can have discipline within the schools. That is a legal solution as well. Probably the last resort in that line should be criminalization, particularly when we're talking about criminalization of children for a behavior that, while deplorable, is also common. Okay? So when we think about new legal tools, we need to think about all the available tools that are out there. And the other thing, when it does come to criminal law, I would suggest that instead of having, solving all of cyberbullying writ large with one piece of legislation, that we need to be precise, specific, targeted, and even incremental, which is not nearly as satisfying to legislators, right? There's a reason they want to go at criminalizing cyberbullying. There's a reason they want to go at it with this broad language about the growth in adolescent cruelty, and let's criminalize that. Because it gets good publicity, and it shows symbolic solidarity with these victims, but it doesn't actually remedy the problem once it gets held unconstitutional. I would argue that with regard to criminal law at least, the term cyberbullying obscures rather than aids analysis. Here's a reason. It's an umbrella term. Actually, I had a nice slide that had a nice umbrella on it with little terms in it. I was very proud of that. But anyway, you can just envision it. So since I don't have a slide, you have to use the mental pictures. Okay, so it's a big umbrella term that includes things like libel. It includes harassment. It includes true threats. It might include fighting words. It might include eavesdropping. It might include impersonation or spoofing. It might include intentional infliction of emotional distress. I could go on, right? Because it's a broad swath of pre-existing categories of behavior. Whether you can constitutionally criminalize that depends on a sophisticated analysis that a lot of these legislators do not seem willing to undertake to address this very real problem. Okay, so for example, it depends, as Professor McDonald noted, on which category of speech you're talking about. It's very easy to criminalize true threats. True threats are an unprotected category. If you want to criminalize cyberbullying that involves making a so-called true threat, that is very easy to do and very effective. Okay? Fighting words arguably could be criminalized, although the precedent of Lidsky versus New Hampshire, which involved calling someone a damned racketeer and a fascist, which wouldn't provoke me to violence, but anyway, it was a different time, different era. That's the last time the Supreme Court said something was fighting words, but it's still on the books, so maybe you could do that. But what about, in the New York statute, one of the things in the justification statement the guy said he wanted to criminalize was profane name calling. Well, profane name calling, most of the time, is constitutionally protected. If you read Cohen versus California, for example, the guy who walked into the courthouse wearing a collector draft jacket, that's constitutionally protected. There's a language where you can call a stab, like somebody who breaks a strike, a traitor to his country, that's constitutionally protected. So in most contexts, profane name calling would be protected. But unfortunately for us, and unfortunately for the poor legislators, I'll give them some sympathy here. I accuse them of sloppy drafting, but I will give them some sympathy. Context matters, okay? Context is another thing that matters in First Amendment analysis that they must be sensitive to. So if you have speech that is said to constitute cyberbullying in a public forum, it gets maximal First Amendment protection. On the other hand, in institutions like work or like schools, you get far less First Amendment protection, as the speakers here have presented. If it's curricular speech, if it's part of the curriculum, part and parcel of the curriculum, the student gets less protection than they do if it's not part of the curriculum, if it's more political. So that's one dimension. The context or the setting of the speech matters to its protection, and you have to take that into account in drafting legislation. What about speaker identity? In the New York statute, it doesn't matter whether the offense is committed by an adult or a child, but it should matter, right? It very much should matter. Adult speech is more protected in many contexts than child speech, right? Children don't have the same First Amendment rights as adults. And there's even a distinction amongst children between older students and younger students. In the school newspaper cases, for example, the Supreme Court has indicated, a college paper is a different entity than a high school paper. So older students get more protection than younger for their speech. And certainly, as you go down the age range, truly younger speakers might not get much at all. I have a 7-year-old. I don't think he deserves much free speech protection, even though I'm committed to free speech. I'm not much committed to it for my 7-year-old. He does fine regardless of that. But, so speaker identity is a factor you have to consider if you're going to draft a statute. What else? Subject matter. Is it public concern speech or is it not public concern speech? I know y'all know Reverend Phelps and the protests at military funerals, right? Extreme infliction of emotional distress. This man went and protested outside of military funerals. And yet, the U.S. Supreme Court protected his speech. Why? Because it's a public concern. So if speech is a public concern, then that was a tort. Criminalizing the infliction of emotional distress probably raises grave constitutional problems, at least if it's in a public setting. And so you have to ask about the subject matter. Is it a public concern or is it not? For example, you know, a student criticizing the hairstyle of another student, I'm sure that's not a public concern. I'm sure that could be regulated more easily than, you know, the black arm that ends in Tinker. Target identity. Target identity. Some of the statutes I've looked at don't even make clear that they're really aimed at children. You know, sometimes when they expand their harassment, they don't make sure to say that they're targeting cyberbullying by speech targeted at children. And you know, some of these administrators calling speech against administrators cyberbullying ignores that a component normally of cyberbullying is an imbalance of power between the speaker and the victim. And so and it matters, right? You get more leeway in protecting children because the state's interest in protecting children are higher. Particularly the younger the children are, the higher the state's interest in protect them. Finally, what about repetition? This is a curious point. I tried to find great Supreme Court precedent on this issue. One instance of protected speech. I call someone a name. Okay? Protected speech. What if I call them that name 50 times? What if I call them that name 100 times? Okay? It should be the case that at some point the speech stops being speech and becomes conduct that can be regulated. And perhaps the Supreme Court's decision in Pacifica, which involved not a fleeting expletive, but a whole monologue full of curse words, perhaps that's authority for the proposition that an instance of protected speech repeated multiple times isn't protected anymore. But all of these have to come into the dynamic when you're trying to pass a law criminalizing speech. And I would say, particularly when you're trying to pass laws criminalizing the speech of children. So I'm incredibly sympathetic to legislatures, but I would ask that they craft statutes with care and precision to try to come up with real solutions. All right, the first question I think that has to be asked is, do we really want to, or which of the behaviors that constitute cyberbullying as currently constituted, do we really want to criminalize? And then the second would be, which specific doctrines of the First Amendment are implicated by that decision? Right now, the legislation tends to have an, I know it when I see it thing. And I would submit to you that we do know cyberbullying when we see it. I have no doubt when I see an act of verbal aggression that transgresses social norms. I know cyberbullying when I see it. But that's not a legal standard. That is an appropriate standard for defining cyberbullying as a social problem. It is an inappropriate standard for defining it as a criminal problem. And so what I would ask is that legislatures try to, instead of passing legislation that merely gives us a symbolic, sense of solidarity with victims, that they craft their legislation with care and precision and a little bit of care from the First Amendment. Thank you.
We have some time for questions, so I wrote some down, but I will let you go first because I want to dominate. So if anyone from the audience has questions, I'm happy to facilitate. Professor Mitchell, of course.
Yeah. Great presentation. Thank you very much. I've got some quick questions.
You're going to have to talk. Oh, that's what that's for. I wondered why I was sitting next to you. You got to come down here. No.
Yeah, all right. The cyber dissing question. The cyber dissing question, the issue about sort of students dealing with, it's not really working.
Yeah.
Is it? Okay. Is a presumption based upon, I think, prior sort of school-teacher interactions, right? If you think about teaching in settings in which teachers face violence, right, or the subjects of assault and attacks, then cyber dissing is not as low-key as we'd like to sort of make it, or as it comes across, but could be the potential of generating a potential sort of violent act against a teacher if you garner enough student support, right? It's not just the, my teacher is sleeping in class, or they're not teaching me torts, or they're not teaching me free speech, or whatever. It's about, I don't like so-and-so, and blah, blah, blah. That's the first one. The second one is language co-optation by certain groups. So gays and lesbians who adopt their own language and call each other those words, if they say it over and over again, or in that context, does that broach potential cyberbullying?
You were first, Barry.
I agree with your comment on cyber dissing. It can, just like any of those forms of student cyber speech in certain forums, it can be very harmful. But I think with cyber dissing, you definitely have different concerns at play. We know that the heart of the First Amendment is to allow criticism of official action, including how teachers teach, how principals administrate. In fact, the very history of the First Amendment, as Professor Wells knows, because she's writing about seditious libel laws, the First Amendment was crafted to allow people to criticize government officials without being punished for it. Now, even there, we have lines that you can't cross. You can't deliver a true threat against the president or anybody else for that matter. And so, it's all about drawing lines. But what the Supreme Court does in terms of trying to address the risk of censorship that, say, cyber dissing may present, censorship by school officials and student speech, that would be implicated in a lot of the run-to-the-mind sort of cyberbullying disputes, is to kind of ratchet up the rules, the scrutiny that is applied to when school administrators administer discipline because of cyber dissing versus cyberbullying. So they wouldn't be as deferential to kind of school administrative authority in the cyber dissing context as they would in the cyberbullying. That's why I think when you think about the analytical approaches that need to be taken towards those two discrete kinds of cases, it's not a one-size-fits-all sort of solution, and that's the only point I was trying to make.
And to the point about members of the individual group using their own language, sometimes taking a word that has previously been used against them as a sword and turning it into something they use among themselves. I think there are two different answers to that. One is a sociological one. And when I talk to groups of young gay teens, for example, or educators who have a large population of gay or minority students in their schools, I often discourage gay students from using those types of language, using that type of language, using gay in a derogatory way, but jokingly among their friends, or using other derogatory terms that other people have levied against us, just because, when you're among friends, you can do whatever you want. It's kind of like when gay men called each other girl, even though that goes right into the stereotypes that many people have of us as effeminate and such. So that's a sociological matter that I would discourage members of the community from using those types of words. It's a legal matter to jump off the very important distinction that Professor Lidsky was making. As a legal matter, there's a big difference it matters in context. Bullying, as a sociological definition and as a legal definition, as Professor Lidsky was saying, includes references to the distinction in power, the asymmetry in power between the aggressor and the victim, and the context that speech is used in. So if it's used in a manner that everyone knows is joking and could not be considered because of its context as harassing or in any way negative, then that's one matter. But still, in order to discourage that kind of behavior, I would recommend that any gay person that I come in contact with not use that kind of language, because that just lets other people say, well, they use it, so why can't I?
One thing I wanted... Hello? One thing I wanted to add about that is it really is, and part of the reason it's different is the absence of the imbalance of power when members of the in-group are using it versus an outsider to the group. But one of the things you worry about in these school discipline cases, I don't know about you all here in Missouri, but I know in Florida, all of my kids get cyberbullying talks, lectures, educations, signed statements all the time. Every child I have one who's an 8th grader, one who's 4th, and one who's 1st. And all of them, even the 1st graders, get a lot of education and training on cyberbullying. What I worry about a little bit, although I definitely think the schools must take the lead in this area, and that they need some discretion to do so, is you get into one of these situations where you have zero tolerance. We have zero tolerance for cyberbullying. And you get a regime where they can't make these subtle contextual decisions that says it's different if one gay student says that to another than if, it's a student who's not a member of that identity group.
Can I jump in with a question? Which actually is for you, Lyrissa. Since you focus on criminal laws instead of the school discipline situation, which Ari is very focused on, and I agree with you that much of the legislation is often rushed into being, and so it has a kind of this panic, abysmal state of drafting, which can be fixed with help. But how do you feel about the situation of school discipline? I mean, obviously you're talking about rules, and those rules are enforced. So to the extent that Ari and Barry brought out their proposals and talked about their issues, do you think the situation is strikingly different, given that you have obviously constitutional implications as well?
Well, I do think the situation in school, I do think the situation in schools is strikingly different. And as I said, that this may surprise you, is I think they need some deference in order to, here's the thing, unlike Tinker, where you had armbands, this is student-on-student discourse. It's private discourse between students. It's an entirely different context. One of the quotes that you used from Hazelwood says, schools can discipline to teach students to learn what lessons the school is trying to teach. Is not a part of the lessons we try to teach children civility in both our public and private discourse? So why do the schools have to have some leeway to impose norms of civility in that discourse amongst students? I just see the school context as being quite different, particularly in light of the harms, the effects, but even without the effects. I think the curricular function of modeling appropriate discourse is so important that I would give them the leeway.
I found it interesting that you focused on the criminal laws instead, so I wasn't sure.
Well, you know why I did? Because I didn't want to get into the whole hard question that Professor McDonald was bolder about getting into. Because I once did all the research to write an article on this, and I decided, I don't know. I decided I wasn't going to go there. But that the line of when off-campus speech gets on campus enough to allow the school regulatory leeway, I think is really hard. And I liked your matrix. I thought it was a nice addition.
But we should, Professor Lidsky is right to talk about the criminal statutes, and undoubtedly. I've written about it a little bit in a different context. For example, Massachusetts, in reaction, I believe, to the Phoebe Prince case, when their statute, which was lauded by all the anti-bullying groups as A+++++. You go online and there's antibullying.org, and they grade state legislation. And they give these inordinate number of pluses after an A. You wonder what the rest of the letters are for. But in any event, the reason why this legislation got so many pluses is because it imposed jail time, 2.5 years, to what they called egregious bullies. And those included some of the sociological definitions that we saw and legal definitions that we saw already. The repeated harassment, targeted an individual or a group, et cetera, and then imposed a certain amount of jail time. And then if you did something else, if it was based on identity, if it was based on something else, et cetera, then there would be more jail time. And then there's another statute that didn't end up getting passed in New Jersey calling for manslaughter charges to apply, this was in reaction to the Tyler Clementa case, calling for manslaughter charges to to apply to these kind of cases. And for anyone who's taken 2 days of criminal law, you can imagine what the proof problems are going to be like in trying to capture someone who may have done something incredibly stupid and incredibly harmful, but would not rise to the intent requirement necessary for that kind of conviction. So talking about these proposed criminal statutes, especially when we allow legislatures to get caught up in the zeitgeist of the time, is especially important.
Other questions? If you do, you can always just walk over there. I'm calling you.
I was curious about the term repetition. I know it's impossible to quantify. You say it once, that's fine, it's free speech. But you say it 10 times, no. Sorry, we're going to kind of like impossible to quantify. But what I was curious about is how the cyberbullying aspect changes that term. Because traditionally in schools, if you walk up to someone and you verbally harass them, you do that multiple times, we think you walked up to them multiple times throughout the course of your education and harassed them. But if I click refresh on my browser or email it to a friend, every time that page is loaded, even in an anonymous context, could that be a repetition, even though it's only one act of cyberbullying?
Well, I'll start. Absolutely. The permanence of harassment of content online makes even a single incident can make a single incident into something much more harmful, given its permanent nature. So, for example, if you wanted to exercise your right to say how terrible a job I did or how awful a teacher I must be, you could put up on Facebook a doctored photo that was taken here today and make all sorts of changes to my face that aren't very flattering. And then you could send it around to all the people who follow me and follow you on Twitter. Even though that's just one picture, that picture is always going to be there. And imagine how if an employer clicks my name into Google, that picture may show up. So the extent to which one single incident can grow or metastasize on the internet is intense, simply because, well, not simply, but one reason is because of the permanence. And Danielle Citron at University of Maryland has written a lot about the result, the effects on women online speakers specifically due to the permanence of online sex-based harassment. Very interesting stuff. And terrible stuff.
I was just going to agree that obviously it makes, if the repetition is foreseeable, which in a lot of these cases it will be, then obviously it means that yes, one thing can be repeated endlessly. So.
And I suppose particularly for you, since you're on statutory interpretation, if that was an element of statute, repetition.
Then I think it's relatively, I don't think that's as much of a constraint because I think it's relatively easily met because of the nature of the technology. So I don't think that piece of the definition constrains as much as we might think it would in the cyberbullying context.
Thank you.
The two true cyberbullying cases that I would have discussed had I timed my presentation better had to do with students posting content on Facebook and YouTube where they invited their fellow students to kind of ridicule and make fun of a particular student. Now to engraft the term, they were basically single incidents of this because, once it got to a certain point, they said stop. To engraft the term repetitive onto that sort of situation, I suppose you could do that if you sliced and diced language. But I would prefer, I think that's why you need kind of the broader version of cyberbullying, which addresses kind of single incident events like that. And then recognizing that you need this kind of broader version to capture these sort of things. Build in terms of the standards that school employ as to whether it can be punished or not. Then build in kind of the free speech protections into that rather than kind of playing with, well, trying to graft repetitive onto these situations where it really doesn't quite fit.
Can I ask then, I was curious when you were talking about your distinction between cyber blustering and cyberbullying, because I think I got that cyberbullying was targeted, somebody received something, and cyber blustering is just like maybe you post something on Facebook, maybe your friends receive it, or maybe maybe you blog about something, but it was just more globally publicly received, but the recipient or the victim rather may never receive it. I guess I don't understand why you wouldn't necessarily make a distinction in the sense of somebody, I can see somebody being viciously taken apart on a public blog or in Facebook, and almost inevitably that always gets back to them, right, at some point. It's pretty unusual for that. So why wouldn't you classify that as some form of bullying? Do you know what I'm saying?
Oh, I'm not saying you wouldn't. I'm just saying that it might be better to kind of conceptualize it a little bit differently, because I think this free speech interest there in allowing kind of students to vent and be students when they're not targeting particular students is a little bit greater.
Particular students. If you identify a particular, I mean, if you take apart a particular identifiable student, right, and let's say not just about what they're wearing, but just. That's sort of largely what was happening to some of these, Danielle Citron, what she writes about, largely having some of these women in law schools. They were viciously discussed.
Yes, but these cases I'm talking about, I mean, that could occur, there's no doubt, but a lot of these cases are where you make your list of 20 students who you think are losers, or you would list of 20 students you wish you would die, so kind
of. Why is that not bad?
I'm not saying it isn't. And what courts are doing is they're not kind of analyzing those cases as cyberbullying, but rather as do they present a true threat to a particular individual, and if they believe there's a true threat, then they allow it to be disciplined if not. Now, I'm not saying that's the optimal situation, but I just think that the free speech versus protective interest, the bullying is a little bit more attenuated. And so, I mean, it's possible if I thought about it more, I might be able to bring in an umbrella standard that would kind of take into account the more attenuated harms that might be caused by that kind of blustering. But I was just trying to make my task easier in terms of kind of figuring out what should the standards be for traditional cyberbullying.
I think, Professor McDonald, I think you're right that courts are engaging in this mesh of applying lots of different types of things to one standard, and that has logical as well as philosophical problems. But I do think that we have to be careful in the kinds of categories that you list out, not only because of the blustering versus bullying criticism. I mean, if you look at hot or not websites, anyone listed on the not, I mean, I think I'm pretty handsome, but if I'm listed on the not, that's a real...
You don't get your chili pepper
no.
right now.
Exactly.
Yeah.
Exactly. So there are certain types of categorization that, while it's true that they may have different legal implications, some of these don't necessarily conform to what we really know the harms to be, but also they border on bringing us the problem that Professor Lidsky mentioned of starting to criminalize or punish something that is commonplace. And unfortunately, it's not so clear to me that we have yet identified the categorization to set aside the stuff that's commonplace, the stuff of immature teenagers with the stuff that really has the kind of psychological and emotional harm. And one possible proposal for that is to distinguish between a real single incident, a single incident that has nothing to do with one's identity. Again, I think there's a very important difference there. But one single incident that has of making fun of someone's hair, for example, that is very common among the immaturity of kids versus the kind of repeated harassment. And those categories may have very clear different implications for how the First Amendment should treat them, and may be easier to categorize than the difference between, say, blustering and actual bullying. Because even with that categorization, we're still not sure what bullying is, because that could still encapsulate a single incident, multiple incidents, and all different types of comments of incident.
Well, all I'm saying is that First Amendment is very contextual, as Professor Lidsky was saying, and that there are different kind of free speech, public interest sort of balance in the cyber blustering cases than in the cyberbullying. And I'm not suggesting at all that certain instances of cyberblustering wouldn't be punishable as bullying. I'm just saying you would want to think hard in developing the standards for addressing an instance of what I've called cyberblustering to make them more sensitive to the greater free speech interests involved in a case like that.
Absolutely.
Are you done?
Okay.
Thank you.
Thank you.
Didn't mean to keep you standing.
It seems that throughout the presentations, there are basically two places that we're placing the burden of protecting the victims on, either through school discipline or through state laws criminalizing the conduct. And it seems there are downsides to both of them. I mean, obviously, with the criminalization, you've got the problem of it's overbroad, you're going to infringe on people's rights, and you've got your right to be free. And then in the school context, you kind of put the school between a rock and a hard place, because if the burden is on them, and they have to enforce these laws in order to protect the victims, but they fail to protect the victims, they're going to get sued. If they overdo it, then they're going to get sued for infringing on people's First Amendment rights. Is there another option?
Absolutely. In fact, studies have shown, including a study that I did in using 6 California high schools of different kinds, a study that I'm trying to expand on, suggested that schools that have more affirmative policies, and what I mean by affirmative are the proactive policies to deal with certain types of harassment. So, again, I was dealing with identity-based harassment based on racial minority, sexual minority, etc. If a school has proactive policies like gay-straight alliances, or student-teacher support groups, or student support groups, parent involvement, other assemblies and multidisciplinary curricular integration that, for example, like the Fair Education Act out of California, which reminds us of the many contributions that minorities have given to society over the years. All of these reduce tensions and reduce the incidence of attacks, single incident attacks, as well as repeated incidents of bullying, much better than the kind of Machiavellian punishments that are in some criminal laws and in some punishments, like Professor Lidsky said.
It seems like you're risking making martyrs by disciplining.
Well, I was going to say, in Missouri's law, they've tried to provide some immunity for school districts who act in accordance with the requirements of this cyberbullying plan. So it gives them civil immunity if they're acting in accordance with the plan. So that's one way to fix the problem, potentially.
I'm a high school principal in the state of Missouri, and I cannot speak to you about the amount of aggravation and confusion and I guess you would call it principal angst over dealing with these types of situations. Professor McDonald, you talked about the National School Board Association, I believe it was, website had 21 off-campus online student cases, that only 2 of them wound up being true cyberbullying instances. I deal with this on a day-to-day basis, and if I get 5 cases in the course, or 5 things that I have to look at through the course of a month or 2 months, the amount of time that is expended when I'm supposed to be out in the classroom making teachers are doing what they're supposed to be doing, making sure the kids are supposed to be doing what they're doing, is a tremendous, and I don't want to call it a waste of manpower, because that's not exactly what I mean, maybe a wasted resource, but I take this so seriously, and it still seems like there isn't a good definition of cyberbullying or even bullying itself, because you've thrown out there the issue of cyber blustering, cyber jesting, jesting. I mean, it's mind-boggling to me in a school where I'm the instructional leader that I've got to take the time to do this, and just as the other speaker talked about, there's no other way to put it. You screw up, you're getting sued here. You screw up that way, you're getting sued there. You do it the other way, you're potentially getting sued there. Would you speak for a moment or two about a real definition of bullying and cyberbullying? Because it really frustrates me and I mean, our school's a good school, but I still have time is wasted and, excuse me, time is spent in dealing with these issues that really I take home with me at night saying, I just don't know if it reaches that value or that threshold of being a bullying or a cyberbullying situation. And then I do have a follow-up. Sorry.
Yeah, in the part of my talk, and I'll address this in my paper, I do talk about how difficult it is for school administrators to enforce these kind of regimes, which are so difficult even for free speech experts to kind of parse through, and how contextualized a lot of these sorts of disputes are. And so I sympathize with your plight. And so I think the answer is just what you had suggested, and I talk about this in my paper, is that we should set up standards for, I mean, I think that the broad definition of cyberbullying it is necessary, because I think single incident events like the type I described can be very hurtful to students. But what I think we need to do is kind of set up certain rules for what schools need to kind of demonstrate in terms of the harm. Is there evidence of harm? For example, was there a complaining victim in a particular case, if you're talking about cyberbullying? Should the student have known that this was the type of speech that could cause distress? So harm and culpability, and then ask students to kind of act proportionately in terms of, do they just give a warning? Is it a serious enough event to give a warning, or is it a serious enough event where, like in these two cases, discipline was actually imposed? But the most important thing is, so I lay out kind of certain standards that I would use to guide administrators. But the most important thing I say at the end is that to make them workable, you've got to give already harried administrators a lot of deference in terms of employing and making these determinations and judgments, so that if they're reasonable, you can rest assured that a court isn't going to be kind of second-guessing you and saying that what you did was unconstitutional. So I think that that's what I propose. That's the best I can suggest, is that we kind of, I'm not sure that, I mean, Professor Lidsky could probably talk to the better definition, because she's been focusing on that aspect of it. But in terms of, once you have your definition, whether or not it's punishable or not, if we can lay out certain things that could guide the school before, and then say, as long as you've done this, like kind of this system in Missouri law that Professor Lidsky mentioned, that as long as you've complied with these certain standards, you're going to be immune from suit. I think that's probably the way to go. Now, you're the expert, so I'll ask you, do you think that that's satisfying?
I think it would be wonderful to have, but I need guidelines. And where do those come from? Are they coming from the school board? Are they coming from the superintendent? Are they coming from me? Are they coming from the legislature? I got to sleep sometime.
Absolutely.
And between basketball games and running school, I don't have I'm not trying to make excuses. I'm not sure I have the time to be committed enough to make a right decision about what you're asking.
One quick question for you. I know a lot of schools are kind of appointing kind of police liaison officers that are trained to deal with these things.
And if our school district had the financial ability to do that, we would have one.
Okay.
One thing I tell you is, it looks like under Missouri statute, it says you shall not be civilly liable when acting in conformity with, and then they do a recourse back to the established policy of discipline developed by each board under this section. So here's how you, in law, we have a special term called CYA. Okay. So here's what you do to do that is you have to, it sounds like that the board has to get together and make out a detailed, if this, then that, if this, then that. And as long as you're following the template that they've contemplated in advance, you've got a lot of leeway. Now the statute's kind of written, it gives with one hand and it takes back with the other, because it says, well, nothing shall relieve anybody of any negligence. So, but it looks like the intent of this thing is we want everybody to have a detailed cyberbullying policy made by their board. And as long as you're following that, you're good to go. So you can punt to the board and then just do whatever they tell you.
These are that's a proposed law, from what I understand. Is that correct?
Yeah, it's
it's proposed.
Yeah.
And what do we do in the interim? There is such an immediacy to. I mean, I left school today. My boss doesn't even know I left to come here. I said I got to come to this.
Well, here's
there's
what
such
I do.
a sense of immediacy that I have to have.
Yeah, here's what I do. I'd sit down and work out for example, if there's any hint of a threat, you're probably safe doing something serious about it. Okay? So any hint of a threat. If it's criticizing your teachers, I would tend to just make that unless it's disruptive, I would leave it alone. So there's like I would sit down and make myself a chart of threats, okay, severe, criticism of teachers, criticism of particularly of a child who's sexual, based on sexual orientation.
Right.
I would take that really seriously, in terms of some solution. I would start with trying to work these things out, but then, so you have to make a sliding scale, I guess is what I'm saying, based on these categories.
Okay. And you're talking.
And you may need some lawyer help.
Yeah, you can be hard.
You're talking only about punishments, or you're talking about general school policies related to.
I'm talking about I would like to see our teachers and our students take a more active role in preventing that kind of stuff, bullying and cyberbullying from happening. And in reality, that would be the best thing to have happen. But I also have to lead that. So I really do take it from a discipline standpoint. For better or worse.
I'm gonna two steps. I'm gonna complicate your life a little bit, and then hopefully try to help you answer. One, in addition to making the sliding scale, you're also going to want to ask yourself, what is the reach of your authority when we're talking about cyberbullying? And Professor McDonald had a test. I propose a relationship test that it was the conduct sourced in a relationship in the school. But all this is we're still talking about it. Courts are still dealing with it. Again, the school should always err on the safe side when it comes to this, depending on the degree of the threat, as Professor Lidsky said, make yourself a sliding scale. Now, for help in this, the Anti-Defamation League, which most people see as simply an organization that is fighting against anti-Semitism in the United States, has incredible resources to help public schools in America write out and educate their faculty members on bullying and cyberbullying policies. One of the best that I've seen for schools with problems associated with anti-gay bullying, I tell them always to look at GLSEN. But for general bullying policies, the Anti-Defamation League, specifically Michelle Deutschman out of LA, is one of the leaders there working on this stuff. And they have some excellent resources and a template policy, which may not work for your school in particular, but is really a good start. It also recommends how you can work with your faculty and parents on those kind of proactive policies. So if you have a moment before you're not sleeping tonight, try to check out the ADL website. They might have some really good resources that could help at least guide you how to create a discussion amongst your faculty.
I'm going to interrupt you, okay? Because we're about 15 minutes over.
I was going to say.
But we are going to have a coffee break outside. Oh, no, this is great. But I'm the second most intimidating professor on the faculty, I'm told. So I'm going to exert that and authority and say that there's a coffee break outside, and absolutely keep discussing outside, but I'm just going to make it unofficial.